Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 151A. As all we know that after 1st April 2021, section 148 proceedings have become a very difficult scenario for the income tax department because one after the other a huge litigation is going on and it is going mostly in favor of the assessee due to very complex provisions and due to frequent changes in the section 148 proceedings. This is the another case in which a very pertinent issue was before the Honorable Telangana High Court, and that issue was that whether the cases related to central charges, that is where the cases is for the such cases, and the cases for the international taxation are also covered by faceless scheme, or in other words they should also be done in a faceless manner. The issue has been taken up by the Honorable Telangana High Court in a writ petition, and the name of the case is King's Pride Infra Projects Private Limited versus Deputy Commissioner of Income Tax and others, and connected petitions. And this case is reported in 479 ITR at page number 651, and the date of the judgment is 14th July 2025. In the present case, the notices under section 148 was issued to the assessee due to the search, and the assessee challenged these notices on the ground that according to the mandate of section 151A and according to the notification dated 29th March 2022 read with e-assessment of income escaping assessment scheme 2022, the case of the assessee can be completed only in a faceless manner and not in a face-to-face manner. Contra to this, the contentions of the income tax department in the writ petition was that according to the e-assessment of income escaping assessment scheme 2022, there are two exceptions which are not covered in the faceless scheme, that are cases related to central charges and cases to the international tax charges. When the court heard the matter and heard both the parties, it was the view of the Honorable Court that there is no dispute that about whether the assessment should be done in a faceless manner or in a face-to-face manner. For this, the court said that the exceptions have been provided by the e-assessment scheme and not by section 151A, which is the authority on this issue. Section 151A talks about faceless assessment of income escaping assessment, and according to the court, in section 151A there is no exception, in section 148 there is no exception, and even in section 153A there is no exception. According to the Honorable Court, whenever after 1st April 2021 any assessment is to be done, then that assessment is to be done in a faceless manner, even if it relates to the previous years which are before 1st April 2021. The court said that section 153A, although have a non-obstantive clause, but even then it has no exception for conducting the assessment in a non-faceless manner. The court said that when there is authoritative decision on the issue of same High Court, then the judicial proprietary requires the bench to honor the view taken by the division bench of the High Court. Friends, this is a landmark judgment, and it gives a very relief to the assessee that now the department, when the department wants to keep his legs on both the boats, whenever he want to pass the assessment in a faceless manner, they are doing faceless manner. Whenever they want to do the case in a face-to-face manner, then they are transferring the case to the central charges. So this is a very welcome judgment, and it is in favor of the assessee that the cases of central charges and the cases of even international tax charges should also be conducted in a faceless manner as per the mandate of section 151A made effective from 1st April 2021. At the end of this video, once again, I am repeating the name of the case. The name of the case is King's Pride Infra Projects Private Limited versus Deputy Commissioner of Income Tax and others and connected petitions. And this case is reported in 479 ITR at page number 651, and the date of the judgment is 14th July 2025. Thank you, friends.